Hello, everyone, and welcome to our second webinar in the Canadian Trademarks series. My name is Kwan, and I'm a principal in the trademarks practice here at Smart & Biggar. I'm based in our Vancouver office. Together with my colleague, Nora Labbancz, who is based out of Ottawa, we are your speakers for today's presentation on fast-tracking trademark applications in Canada, expediting Canadians' trademarks examination. I'd like to get started with a couple of housekeeping matters. So our formal presentation today should run less than 30 minutes and will be followed by an open and interactive Q&A session where we will address specific questions you may have on the topics we cover today. You're welcome to submit questions at any time during the presentation by typing them into the Q&A panel in Zoom, which can be accessed by clicking on the Q&A button at the bottom of your screen. Please do not type your questions into the chat panel. We will try and address as many questions as we can during today's live session or in follow-up email after today's session. Today's webinar will be recorded, and following the presentation, we will circulate an email with a replay link together with a PDF copy of our slides from the presentation today. Lastly, at the end of the webinar, a link will pop up to complete a survey. We would appreciate if you could take a few minutes to complete the survey with your feedback on today's webinar, as well as what topics you're interested in learning about in the future. Finally, before we begin today's webinar, we would like to offer a land acknowledgement. In the spirit of reconciliation, we respectfully recognize and acknowledge that the land we are meeting on and that all Canadians live on, work on, and enjoy is the traditional territory of many nations. These lands are now home to many diverse First Nations, Inuit, and Métis peoples, and are covered by various land treaties. In Ottawa, where Nora is situated, the land is the traditional unceded territory of the Anishinaabe Nation. Vancouver, where I'm located, is part of the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh Nations. And now we'll begin with a brief introduction to Smart & Biggar. And before that, just so you know what we look like, just a slide with us. So who we are. So Smart & Biggar is Canada's leading IP law firm, and we have experience and strength in IP, but not only IP, we're at the interface of technology and business law. We have experience handling issues across all manners of IP. We've been doing this for over 130 years, serving clients and providing top-notch service. We have over 100 lawyers, agents, and technical consultants with the firm. On an annual basis, we file over 8,000 patents and trademarks. And we have not only that, we have very strong litigation bench strength and a track record of success in the courts across Canada. Moving on to our presentation today, here are the topics that we will be covering in the next half hour or so. So we'll begin by talking about the delays at the Trademarks Office. Many of you on our call today will be aware of that, and we want to provide a bit of background and discuss how we got here. We'll discuss the current delay times to examination, which will be of interest to many of you. We'll discuss what the Trademarks Office is doing about the delays. They certainly know there's an issue there, and they are taking some steps to address that. We'll then go through some options that are available to applicants for speeding up the application process, including what we call expedited examination and what we call accelerated examination. And after that, we'll have a question period, as I previously discussed. And with that, I'll now turn things over to Nora.
Okay, thanks, Kwan. So as Kwan mentioned, it's probably no secret that the Canadian Trademarks Office is significantly backlogged. But how did we get here? So according to the Trademarks Office, this situation is what they call a perfect storm, which was created by the convergence of several different events, including the three main ones that are on the slide. So first, in 2019, we had sweeping changes to Canadian trademarks law come into force. It was effectively a complete overhaul, and so everyone had to be retrained, which inevitably led to delays. Also in 2019, Canada acceded to the Madrid Protocol, and so that required the office to set up an entirely new division and train a set of examiners on the protocol, which, as many of you know, is quite complex. The office also didn't anticipate just how popular Canada would be as a designation. And actually, in 2021, Canada was apparently the fifth most popular jurisdiction in the world for Madrid designations. While that type of success is obviously great for us, it also meant that the Trademarks Office wasn't prepared to handle such a large influx of incoming applications. And then finally, in 2020, there was, of course, the pandemic, which came with its own unique set of challenges. One of the main ones being that the office had a completely paper based system for nationally filed applications. And so when the provincial government mandated lockdowns, during which employees were prohibited from going on site, the office just couldn't continue its normal activities like printing and mailing examiners' reports, and the whole process was just further backlogged. Next slide, please, Kwan. So what are the delays like now? Well, on the screen is a slide, or sorry, on the slide is a screenshot from the Canadian Trademarks Office's website that I took last week. And as you can see, according to the office, it's currently examining directly filed national applications that were filed the week of March 27, 2019. That means that the delay from filing to examination is about 50 months, so more than 4 years. As for Canadian designations, the Madrid Protocol requires examination to occur within 18 months. And you'll see at the bottom of the slide there that the office has managed to get examination times for those applications down to about 16 months. That being said, it is worth noting that subsequent examination is currently much slower for Madrid designations. So, in other words, if you receive a provisional refusal and file a response, it can currently take the office about 12 months to review the response and take the next action. Whereas for nationally filed applications, I believe the delay in reviewing responses is about 6 months. Next slide, please. So what is the Trademarks Office doing to address the delays? As Kwan mentioned, the office knows about the delays, obviously, and they're taking it very seriously. So they have a number of initiatives that they're pursuing to improve both time and efficiency, including the ones that are highlighted on the slide. So one of the most serious problems they're facing is that there just aren't enough trained examiners. And so to address that problem, the office is continuing to recruit and hire new cohorts of examiners and then train them up. But obviously, that takes some time. The office has also completed the process of digitizing its files, and it's actually been 100% paperless since January 2023. And actually, one of the many, many benefits of that is that the office can now apparently recruit from across Canada, which increases the size of its candidate pool. Another initiative they're pursuing is revamping examiners' reports. So, to improve timeliness and efficiency, the reports are going to be simplified and they're going to be issued in a standardized format. They're also going to limit the use of case law in first reports and provide fewer examples of acceptable goods or services. The office is also looking to improve its IT tools. So, for example, they're looking at integrating an AI solution and machine learning into part of the decision making process during examination. The next two on the screen I'll talk about in greater detail later on, but as many of you know, the Trademarks Office provides a searchable database called the Goods and Services Manual. And the manual contains terms that have been pre-approved by the office, meaning that if you select a term from the manual, the office will accept it without further specification. Now, for those of you who are familiar with Canadian trademark prosecution, you'll probably know that most objections raised, and I think it's something like nearly 65% of all objections raised, relate to the specificity of the goods and services. And these types of objections are time consuming both for applicants and for the office. And so what they're doing is they want to encourage people to use the pre-approved terms from the manual. And to do that, what they've been doing is sending letters to applicants, encouraging them to use the pre-approved list. They've also significantly expanded the number of pre-approved terms in the manual. Finally, the Trademarks Office is increasing the number of applications they examine each year. It's been quite significant, and apparently their inventory has been consistently decreasing. So with that, I'll turn it over now to Kwan to tell you about expedited examination.
Thanks, Nora. So expedited examination is the first of the two options we'll discuss today, and it is the real fastest way to get a Canadian trademark application examined in the current system. And it's so fast that typically upon submitting a request, you'll have examination if the request is granted, of course. Examination will take place within 1 to 2 weeks. And that to me sounds a lot better than 50 months. However, in cases like this, you do require affidavit evidence. So not every applicant is going to be eligible for this option, but it is certainly there and worth considering given how fast examination can happen through this option. So there are 3 criteria that we'll discuss today. There is a 4th criteria that we won't mention today as it's very rare and not really something that comes up too often. But these 3 scenarios are the ones that come up the most often when it comes to requesting expedited examination. So the first is if an applicant is contemplating or has commenced litigation in Canada relating to the trademark at issue. The second is if the applicant is combating counterfeit products at the Canadian border. And the third option or scenario is the applicant is seeking to protect its rights from being severely disadvantaged on online marketplaces. And I'll spend the next few minutes going into some of these different scenarios. So the first scenario is a court action. So in this case, the requirement is that a court action is expected or underway in Canada with respect to the trademark in association with the goods and services in the application. In terms of the affidavit that needs to be submitted to CIPO, that affidavit should discuss the litigation that has been commenced or which is expected to be commenced in respect of the trademark. So it's worth noting that litigation doesn't have to be underway yet. Contemplation of litigation will suffice to persuade the Trademarks Office to grant expedited examination. Now, with respect to the issue of expecting a court action or contemplating it, CIPO was initially quite lenient with that language, and we were able to push forward cases with language that didn't really get into the details. However, based on recent experience, it appears that CIPO's stance has tightened, and if an applicant is now relying on expected court action, some details need to be provided in the affidavit filed in support of the request, and that includes some factual background, though there's no need to identify the parties by name, as well as steps taken in anticipation of the litigation in Canada. The second scenario relates to the fight against counterfeit products at the Canadian border, and specifically, this requirement states the applicant is in the process of combating counterfeit products at the Canadian border with respect to the trademark in association with goods or services in the application. So in this case, the affidavit should set out that the applicant requires a registration to record its rights with the CBSA, which is the Canadian Border Services Agency. And indeed, the CBSA will only record registered marks. So if you have an unregistered mark, that won't do. And so that is an obvious fact that should go into the affidavit. And it's a necessity given the way the CBSA operates with recording marks. The affidavit should also refer to any anti-counterfeiting actions that have been taken by the applicant. Now, this is not required, and it's not to say that only applicants that have histories or established anti-counterfeiting programs are eligible. But if there are such programs or such history available, providing those details can be persuasive to the person considering the request for expedited examination. And I know that we have been successful without these details in cases past, but nevertheless, if such details are available, the idea is to provide the examiner with as much information as possible in support of the request being made and to set out the background and history, if available, of the applicant, of the counterfeiter, and steps taken by the applicant, if applicable, should be included in the affidavit. So the next scenario is where an applicant may be disadvantaged on online marketplaces. So in this case, the requirement is the applicant requires registration of its trademark in order to protect its intellectual property rights from being severely disadvantaged on online marketplaces. So the idea here is that an applicant is dealing with infringers or counterfeiters on the internet, very commonly on Amazon and eBay, but other sites can be used as well. We've seen Etsy, Alibaba, and other sites as well. In these cases, ideally, the affidavit should set out a background and history of the applicant's online e-business, the activities going on at the infringer's end, and any steps that may have been taken by the applicant to date. And again, the idea is really just to give the examiner a sense of the background, the history, what is going on, and why expedited examination is required to assist the applicant in its efforts. If applicable, screenshots of the infringing listings, postings, or sites that are advertising the counterfeit goods or the goods that are setting the applicant back in terms of online activity, they may be appended as exhibits to the affidavit. Again, just providing as much information as possible for the person considering the request. The last scenario I'll mention isn't one that has come up as often now that we're about 3 years into COVID. Certainly COVID is still around and is a thing, but I did want to make mention of this in case it is useful to anybody on our call today or any of your clients. And this scenario relates to COVID-19 products and services. So where the goods or services being applied for are medical goods or services that prevent, diagnose, treat, or cure COVID-19, and this can include pharmaceuticals, medical devices, protective equipment, medical services, or medical research services, this scenario can come into play. And the application must include at least one of this type of good or service. And in addition, the applicant must also have obtained approval or at least submitted a request for approval for use of the goods or services in the application to Health Canada using that trademark. So, and I haven't dealt with one of these cases personally. It's certainly available for situations where COVID-19 is in play as the type of good or service. So I leave that as an option for those who might be interested in it. So just a few last comments on expedited examination. Again, it is the fast track way to having an application examined in Canada. I recognize it's likely not available to brand owners in many cases, but just given how much more quickly examination can proceed, it's certainly well worth thinking about whether an applicant may fit any of the aforementioned criteria. As I mentioned before, there was a bit more flexibility, I think, at the outset in trying to finesse an applicant into one of the criteria, but certainly CIPO is open to thinking and considering whether criteria apply, and there's no harm in attempting to seek expedited examination. At worst, CIPO will say no, and as you can see on our slide, the success rate is very high. As a firm, we're batting over 90%, and I think that's probably a reflection of a few things. One is I think in many cases we are proceeding with examples where we have a lot of affidavit evidence and it's really a slam dunk in terms of proceeding. I'd like to think that we're also doing a good job of getting information and being persuasive and getting that in front of the examiners making the request. But I do think given how high this number is, it is really worth thinking about this as an option where it's possible for an applicant. Finally, with respect to costs, it's not prohibitive in most cases. There's no official fee to request expedited examination, but of course there are legal fees involved for the preparation of the affidavit and the submission of the request to the examiner. And with that, I will turn it back to Nora to discuss accelerated examination.
Okay, thanks again, Kwan. So this part of the presentation will discuss, as Kwan mentioned, the other option for fast tracking an application, which doesn't require a request or an affidavit. However, this option is unfortunately currently only available for nationally filed applications. So I mentioned earlier that the Trademarks Office has a searchable database called the Goods and Services Manual, which contains a list of terms that have been pre-approved by the office. Now, if all of the goods and services in an application as filed are from the pre-approved list in the manual, then the application is fast-tracked automatically. The way that works is the office has software that checks all newly filed applications and it flags them if they're compliant with the manual. Now, if the goods and services in the application as originally filed don't comply with the manual, but you amend them after filing to comply, then examination will also be fast-tracked because amended applications are also run through the office's software. So just how much is examination accelerated? Well, as I mentioned earlier, and as you can see on the slide, the delay from filing to examination is about 50 months for a nationally filed application not using the pre-approved list. If your application is flagged as being compliant with the manual, then examination is accelerated, meaning that the delay from filing decreases to about 22 months. So the benefit of seeking accelerated examination is over 2 years, which obviously is significant. Next slide, please. So apart from the quicker timeline, there are other benefits of using the pre-approved list. So for example, as I've already mentioned, with accelerated examination, there's no need to file an explicit request or an affidavit. Additionally, as some of you may know, the office retires terms from the manual from time to time, and that's if they decide that a particular term is no longer sufficiently specific. And that means that a term that's on the list today might not necessarily be there tomorrow. And the slide there has a screenshot from the manual showing what it looks like when a term's been retired. So those are the ones that are highlighted in red. And there's also a link to the manual on the slide in case you want to access it yourself. But so what happens if you select a term from the pre-approved list in the manual, your application is flagged as compliant, but then one of the terms is retired like 3 months later? Will the application still be fast-tracked? Fortunately, the answer is yes. Once the application is flagged, examination will be accelerated. Your application doesn't just get plucked out of the queue because the term has been retired. Finally, another benefit of accelerated examination is that you could possibly avoid receiving an examiner's report altogether if there are no other issues. So the office has noted that something like 70% of applications filed using the pre-approved list proceed straight to approval without any examiner's reports. Next slide, please. Since the option for accelerated examination has been available, there have been a number of improvements made to the process. So, for example, I briefly mentioned earlier that the office is committed to expanding the number of terms in the manual, and I believe that we're now currently over 134,000 terms, and that should make it more attractive for applicants to use the list as it continues to grow. The Trademarks Office has also recently advised us that its software has been updated. So there's one example on the screen of the update. So let's say your application covers two products that are described as clothing, namely t-shirts and pants. And the terms t-shirts and pants separately are on the pre-approved list, but the entire term clothing, namely t-shirts and pants, isn't on the list. Previously, our understanding was that the examination of the application wouldn't be accelerated because the exact term wasn't on the list. However, the office has just recently advised us that their software has been updated and it can now identify that the terms after namely are compliant. And so examination should be accelerated. Finally, I mentioned earlier that the office is encouraging applicants to pick terms from the list by issuing letters, and these are called pre-assessment letters. The letters basically tell applicants whether or not their application complies with the manual. If so, the letter says examination will be accelerated, no further action needed. If not, the letter would invite the applicant to bring the goods or services into compliance with the manual. But the frustrating part was that the letters wouldn't specify which terms in the application were compliant. So you would need to go through the application and review each term, compare it to the manual, and then figure out which terms need to be amended. Now, the office has advised that the new letters will specify which goods and services in the application are compliant. Next slide, please. Okay, so now that we've gone through the benefits of accelerated examination and some of the improvements, there is one thing that's important to note. So a term doesn't need to be on the pre-approved list in order to be considered acceptable. There are an infinite number of terms that are acceptable to the office that aren't on the list. However, if your application includes such a term, examination won't be accelerated. So here's an example. Let's say your application covers a single product, snowblowers. The term snowblowers appears on the pre-approved list, so your application is flagged and it's accelerated. But what if you sell snow blowers and parts for snow blowers? Well, in that case, you might want to include snow blowers and parts therefore in your application. Now, this description is acceptable to the office, so they won't raise an objection. But unfortunately, because that term isn't in the manual, examination wouldn't be accelerated. So then the question becomes, well, what do you do if you want accelerated examination, but you don't want to amend or select all the descriptions from the pre-approved list? And we'll leave you with some tips. So next slide, please, Kwan. Okay, let's take the example where you have an application covering 10 goods. 6 are from the pre-approved list, 4 are not. You want accelerated examination, but you don't want to bring the 4 terms into compliance with the manual. What do you do? Well, one option that's been available in Canada since June 2019 is to file a divisional application. So specifically, you could leave the 6 terms from the pre-approved list in the parent, and then you can file a request that the 4 which are not on the pre-approved list be divided out of the parent and included in a divisional application. In that example, the parent would be flagged as compliant, and it's going to be examined on an accelerated basis. And unfortunately, the divisional application would kind of chug along and be examined in the normal course. Next slide, please, Kwan. Okay, if we take the same example, so 10 goods in the application, 6 compliant, 4 non-compliant, you want to accelerate, you don't want to choose terms from the manual that are already there. Well, another option you could consider is whether it's appropriate to file a request that the term be added to the manual. And as I mentioned previously, the office is committed to expanding the pre-approved list. And so they will consider requests to add new terms to the manual. And this might be an appropriate option if the term is sufficiently specific, and particularly if you're planning on using the same terms in future applications. Suggested terms can be submitted in either English or French, and they would typically be accompanied by brief submissions as to why the term should be accepted for inclusion. And notably, the current processing time for these kind of requests is about 3 weeks from receipt of the request to publication in the manual, assuming, of course, that the request is accepted. Next slide, please. Okay, so I'll leave you with just one final example, and this is definitely one that doesn't come up very often. So let's say you have a long list of goods or services and you're a large volume filer. You're planning on using that exact same list for future applications. Well, one option for accelerating examination is to submit the entire list of goods or services to the Trademarks Office for review and approval. The office will review the list and they'll tell you if any of the terms aren't acceptable. So in that regard, it's important to note that all of the terms on the list have to be acceptable, and so any unacceptable entries have to either be deleted or amended. And then once the entire list is approved, it's integrated into the office's pre-assessment tool, and it can be used by the same applicant in future applications. That means that the custom list must be approved before your application is filed. But unfortunately, the issue with that is that depending on how long it takes to get the entire list approved, it could significantly delay your filing date. Okay, so next slide, and I believe that's the end of our prepared portion of the presentation.
Thank you, Nora. So yes, that brings us to the Q&A portion of today's presentation, and we'll take a look at some of the questions that have come in. So we've got a few questions here, and I will start with the first one we have here, which is, for an application made in the early fall of 2022, September, using the approved categories and terms, what is the best approach now to expedite the application? No litigation commenced or expected, just a proposed trademark already in use. No true concern about another competitor using it currently either. So I think, Nora, that this would probably fall into your realm just because there's no litigation commenced or expected.
I think so. So, assuming that it's a nationally filed application, it sounds like you don't have to do anything. If you used approved terms that are all in the manual and every single term in the application is from the manual, then examination should be accelerated automatically without needing to do anything else.
Yeah, and I think I would just add that even though there's no litigation commenced or expected, to the extent that there's any issues with online infringers or there's anything going on at the border with counterfeit goods, those are also categories that can be considered with respect to expedited examination. I should also note that for expedited examination, you can, of course, rely on more than one of the scenarios. You could have all three, or two of the three, or just one. It's not you have to fit only in one category, of course.
Okay, I'll take the next question here, and I think this one is for you, Kwan. So, what basis do you use most often for your expedited examination requests? How do you manage your clients' expectations in respect to examination delays?
Great. Those are good questions. For the first question, what basis uh, is used most often for expedited exam requests? I would say I don't have the actual statistics in front of me, but I believe the most common would probably be either online disadvantage. I think that's probably the one. Possibly anti-counterfeiting, and that's probably partly because we have quite a few clients that are very active in the anti-counterfeiting space. But I think the online disadvantage makes the most sense. I think can be widely applicable across many industries, and it happens to a lot of successful businesses. They have their brand, they start selling, and all of a sudden on eBay or Amazon, there's a knockoff. And once that happens, then that sets you up for expedited examination. So I think my answer would be likely the online disadvantage category. The second part of the question there was how do we manage our clients' expectations in respect to examination delays? Well, we apologize on behalf of CIPO, I suppose, but I think the idea really is just to keep clients abreast of what's going on. Certainly act quickly when examination does take place, but really just keep in mind whether there are any of these options that are available to them. To let them know that if they do want to use the pre-approved list, that will speed things up a lot. And certainly if there are any reasons to believe that they fall under the categories for expedited examination, to pursue that. So I think it's really just letting them know what's going on. And we're all in this together. It's unfortunate the delays right now, but and CIPO has given us some options here to take advantage of some fast tracking. But other than that, there's really not too much else we can do. Okay, so the next one, Nora, I think is for you, but I think we've already discussed this, but I'll read the question anyway, which is, can we submit additions to the Manual of Acceptable Goods and Services?
Yep, so the answer is yes, you could definitely submit them. And the office is pretty eager to consider requests because they want to expand the list, because they want it to be more useful to people, and so that they make more use of the manual. Okay. Do you file a request for a divisional application electronically? I believe that currently there is no, and Kwan, you can correct me if I'm wrong. I believe that there's currently no dedicated e-service for filing a divisional application. So you could either file, and you could do it electronically through the general correspondence. You can file online a request to divide the application, and you basically specify which of the goods should be limited in your parent, and then which you're dividing out and should appear in the divisional. I think alternatively, you can also amend the original application through the e-services, and you can limit the goods and services in the original application, and then in the closing comments, you can say which goods you wish to divide out into a divisional.
Okay, the next one, I think this one is for you as well, Nora. How long does it typically take to get a custom list approved by CIPO?
It's a good question. I'll be honest, it's a very rare situation because it is intended for larger volume filers that are planning to use it. Um, In the experiences that we've had, it has taken quite a long time, but the custom lists that we were submitting were pages and pages long. So because every term in the list has to be acceptable, it can take a while and it could be a lot of back and forth with the office. So I don't have a concrete example for you, but I would say it would depend on how complicated the goods and services are and how long the list is. I don't know if you have anything to add to that, Kwan.
Nope, I don't. I think that's all right.
Okay, I think this one is also for me. So what would be the acceptable reasons to add the goods and services to the pre-approved list? Um, so I think the question here is, if I'm interpreting correctly, is what do they consider when adding goods and services to the manual? And the answer there is that the office applies the same principles as they do when they're examining an application. So they consider a three-part test, which is basically one, is the term described in a manner such that it's possible to assess whether the trademark is clearly descriptive or deceptively misdescriptive? Two, does the description identify a specific good or service to ensure that you're not being given an unreasonably wide ambit of protection? And the third is the term sufficiently specific so they can assess confusion? And if the term meets all three of those criteria, then it should be accepted. But I will note that if the term is particularly lengthy, they could reject it. But in that case, they should propose something that's shorter and broader for addition to the manual.
All right, so we've got a few more. We're running close to 9:40 my time or 12:40 in the Eastern time zone. So we'll take a few more questions before we wrap up. Um, this is an interesting one. This one will be for me. Can you speak to the fourth category for expedited examination based on foreign registrations? When is this actually applicable? We have not seen this in practice yet. Great question. So somebody actually asked about this, and I had made reference to it in my presentation. It certainly hasn't come up for me personally. I'm aware of this fourth category, and I believe it applies in certain jurisdictions where there is a requirement to have a mark registered in order to claim priority. And I seem to recall, but please don't quote or cite me on this. I seem to recall the Philippines might be a jurisdiction where this is required, where you need to have an actual registration to claim priority or to perfect a priority claim. And so that is a basis for requesting expedited examination in Canada. And I suspect that they'll want some information or details. I don't know actually whether you would need to submit an affidavit, but at the very least, I think the submission would at least need to include the details of the foreign application and any deadlines that might be applicable. And I suspect that would be enough to support that request, but I have not handled one myself, and I'm not aware of any of my colleagues having handled one before. So this is certainly not a common category, but those are the thoughts that I have on it. Nora, if you've come across one or handled one, please feel free to chime in.
I have not. I've not. Okay. Um, Next question. Are you aware of the new law in Quebec modifying the Charter of the French language? If so, do you know if these new regulations could be a reason to accelerate an examination? I think that could be for you, Kwan.
I'll take the question. We're certainly aware of the new law in Quebec relating to the charter, and I believe we have a webinar presentation coming up later in our series about that. To my knowledge, at this point, these new regulations are not a reason. I know the question says accelerate, but I'm thinking expedite as well. I don't think that's a basis. In terms of expediting examination, as I mentioned, the office is very strict about the categories, and unfortunately at this time, this would not qualify as a basis for requesting expedited exam, but things could change, and certainly if that happens, we will be the first ones to let you know. Okay, I'm just looking at our time right now. We're at 9:43 or we're 12:43. We will take two more questions, and I think we'll call it a day. So the question here is it common for a business to have an anti-counterfeiting strategy to document and provide within an affidavit, but not have already gone through the process of application for trademark examination for registration? This seems counterintuitive. I think the idea here is that you can have an applicant that's filed an application and something comes up and there's counterfeit activity. At that point, they may wish to pursue expedited examination. And so in making that request, you would put in information about your anti-counterfeiting strategy, steps that you may have taken, the program that you have set up to deal with counterfeiting. So I don't know if I totally understand the question, but I think the idea is that even if you have an anti-counterfeiting strategy, there may be cases where you need to expedite examination. Despite best efforts, you can file applications, but as we talked about, the delay to examination is so long that you may have filed an application, but maybe you were not in a position to support a claim for expedited examination, and then something has come up, and you're now eligible for it. So in making that request, you would, I think, want to lay out the steps you've taken and any kind of strategy or history or background that you have.
Okay, I will ask the next question. So, have there been any cases recently where there has been an expedited application for potential infringement and disadvantage to the online business due to virtual infringement in the metaverse that can be traced to a different jurisdiction?
I guess I'll take that one. I think my correct answer is I don't know. Just because I of course don't know of every case for expedited examination that's ever been or that is being requested. So I don't know. I haven't handled a case like that recently or at all. To be honest, it sounds like a good case to put forward, but I think the answer for me is I don't know. And Nora, if you're aware of any cases, please chime in.
No, unfortunately not.
Okay, so so I was going to say, okay, we're going to close it off. There's one more question. I was going to take it, but I know now that we are at 12:45 and more questions are coming in. So unfortunately, I think in the interest of time and respecting everyone's time, we're going to cut it off today. There are a couple of questions I see that are outstanding. We'll address those by follow-up email today, but yes, I think we should call it. So we've reached the end of our scheduled time for today. We are wrapping up. Please, if you haven't completed the survey, do so when the link pops up at the end of the webinar. Any feedback is greatly appreciated. And so in closing, thank you very much for taking the time to join us today. Hopefully, we will see you on July 13th, which is our next webinar in our series. And that one is titled Trademark and Copyright Enforcement on the Internet, Online Marketplaces, Social Media, and the Web. Thank you again, everyone, and have a wonderful rest of your day.